Yes, Miss Meyer.
May it please you, my lords, I appear on behalf of the appellant mother in this matter. My learned friend, Mr. Cummins, and I appear with my learned junior, Miss Edwards. My learned friend, Mr. Cummins, appears on behalf of the local authority who are responding to the appeal. My lords, I think you're aware that there's also within the bundle a skeleton argument that was filed on behalf of the child.
Yes.
And I think, my lord, you gave permission fairly recently for them not to attend the hearing, the skeleton argument being very much in line with the local authority approach on this matter.
Yes, Miss Meyer, before you begin,
Yeah.
can I just emphasise one point where, in the court's experience, it's very easy for all of us, including members of the court, if I may say so, occasionally to forget that the hearing is being live streamed, and therefore it's all the more important that we should not identify the child or other names or matters which might lead to the identification of the child. I know it can very easily be done by a slip of the tongue, but can I just ask all the advocates to bear that in mind?
Certainly, my lord, I will try and deal with simply the mother, the father, local authority, child, and the other main reference will be the social worker. But obviously I'll try and make sure that I don't lapse into more detail than that. And my lord, obviously behind Miss Edwards are the mother and her legal team. Behind Mr. Cummins are the social worker and team manager.
Right.
My lord, do you wish me to move? I saw you looking.
Just trying to work. I've now worked out who your client is, Miss
Thank
Mayor.
you. My lords, obviously, the court is concerned with an appeal in relation to the child I, who is now just over a year old. And the mother, just so that this is in context for the court, I'm sure you'll have read the papers that identify this, was only 20 years of age at the time of birth and is only 21 years now at the time of this appeal hearing. And the appeal is against the judgment and the decision that was made on the 3rd of March of 2023 by the recorder sitting in the Worcester County Family Court. And my lords, I'm hoping, but please do tell me, that you've had an opportunity to read the transcript of that judgment.
Yes, we have.
Which appears within the core bundle, and to also read the various skeleton arguments.
We have.
Thanks. The transcript of the judgment, may I just add this detail, and I'm very sorry, because Miss Edwards is in the unique position of being the only trial advocate who is present in this courtroom on the appeal. And it's information that has been updated for me as we were going through the papers again. The transcript that you have is rightly, I think, described as it starts effectively as an extempore judgment, but in this sense. So at the hearing, which spanned 2 days, all of the oral evidence was dealt with on the first day, and that was the evidence of the social worker, the mother, and the children's guardian. The second day was devoted to submissions, but then there was a period of time over which the learned judge adjourned before he then came back into court to give his oral judgment. So in the core bundle at page 43, so the transcript of judgment, you can see that the start time for that judgment is given at 15:58. The finish time is 17:32. There was a break during the course of that. You will have read in that judgment that the mother became upset and absented herself, understandably, for a period. But the submissions had finished before the luncheon adjournment, and I think it was around 12 or 12:15, the point at which the learned judge retired. Because although it's described as an extempore judgment, it is in fact a fairly detailed judgment, more than you might otherwise have anticipated. The process obviously was then gone through, that the transcript of the judgment was requested, and that was in fact received back on the 22nd of May, presumably after the correction process that the judge would have been able to engage in. Now, my Lord, Junior Counsel has set out in the local authority skeleton argument effectively 4 headings.
In your skeleton argument?
In our
you said
skeleton,
local
my
authority.
apologies, yes, my Lord. In our skeleton argument, it has been set out 4 headings for the grounds of appeal.
Yes.
They're replicated in the skeleton argument from the original grounds. But can I perhaps just try and categorise some of the matters where we know we've come under attack from the other respondent skeleton arguments? It is not accepted in our submissions to you that the appeal stands or falls on whether the judge in October was right or wrong to have refused the application for the psychology assessment, the Part 25 independent expert. It does not stand or fall, even we say, on that mere fact of the decision of the judge in March about refusing the psychological assessment. And further we say it does not stand or fall on the learned judge's finding or categorisation that the local authority in that October hearing had misled Her Honour Judge Bajaya as to various parts of the evidence that were cited from the position statement on behalf of the local authority, which the learned recorder found had not been made out and in fact were not underpinned by evidence at the final hearing. Now, those particular elements of evidence were also repeated in the local authority parenting assessment and relied upon as part of their final evidence, in effect, for submitting to the court that a placement order and therefore a plan for adoption for this young child was required, and the only outcome effectively that would meet his welfare interests. And my Lord, may I take you to the local authority skeleton for that October hearing, which is within the supplemental bundle. It is the position statement that appears at tab 11 and starts at page 77, just so that we can see the type of information that the court was being provided with in what was not a sworn or indeed categorised as a statement of truth. It was a position statement. And it is these words in particular, under psychological assessment on mother on page 78. Mother has spent a period of 2 weeks in hospital, then followed by paragraph 13, living a really chaotic lifestyle, partying, drinking and taking drugs. Met a number of different partners, is the following on paragraph from that. Social worker has described a pattern prior to Sebastian being in mother's care where she places herself in risky situations, has not taken support offered to her from adult services. Home conditions are described as atrocious, with the mother is reported as very flippant about. And it is those categorisations and the language that is used that we say indicate just how seriously the local authority felt the evidence demonstrated lack of care by this mother. And as we say, that was effectively the approach that they adopted at their final evidence stage and at their evidence before the court and the learned recorder. Now, if I may also take you at this stage.
Just before you leave that document,
Yes.
I note from page 80 that it's signed by someone described as locum barrister, childcare.
I'm sorry, I'm jumping in before you've asked the question.
I'm just wondering what the status of this document is. It's headed position statement.
Yes.
It doesn't appear to be evidence in the strict sense.
It's not. And I think Mr. Crummins would agree with that. It's not evidence direct from the social worker in the normal way of providing social work evidence in a statement with an attestation of truth.
If we turn, Ms. Mayor, forgive me, if we turn to the next page, page 81, we can
Yeah.
see that the author of the document represented the local authority at the hearing before
Yes.
Judge Brigade.
And I'm assuming the description of locum barrister, but again, I may be guided by my learned friend, means that she was an employed.
Her email address suggests that's
Yes.
right.
But then can I, following on from that, take you to what was an agreed note of judgment of the advocates who appeared in the October hearing, and it's page 86. Where you can see, it's a fairly brief note, and if we start 6 lines down, the learned judge said this: I accept it as a position statement, not a witness statement, and I will direct the local authority to file primary evidence. She then makes a comment about the update would have been shared with mother, and again, this was not a hearing, as I understand it, at which any oral evidence was taken, so it wasn't backed up by evidence from the witness box. She goes on to say, the local authorities say mother continues to live chaotic lifestyle, no significant changes made since the child was moved from her care. She may be disheartened by the process and delay, and she's had medical difficulties at the time of this application. And then 2 more lines down, the local authority need to file primary evidence, and the local authority need to file a parenting assessment in due course. Now, they do file the parenting assessment, which is the social worker who is present in court, her November 22 document, which reiterated many of the concerns that are relied upon to not oppose, but to not support the mother's application for a psychological assessment. And then it goes down further. Right in the final 5 lines, a psychological assessment is not necessary to determine contact issues, and I take the view there is sufficient evidence, no gaps in this evidence, which I accept is yet to be forthcoming in respect of recent updates. Once that is before the court, I do not find that a psychiatric assessment will fill a gap in this evidence. Mother's mental health is one aspect of this case, and the court has to consider if there is sufficient evidence to make a final decision. And so it was clearly intended by that judge that the local authority should file what she referred to as primary evidence of those particular allegations. Now, when we look at the judgment, the transcript of judgment, there are some clear indicators from the learned recorder about the lack, even at the final hearing, of evidence to underpin those allegations that were made. And if you bear with me one moment. If we go to page 56 in the core bundle, and if we start at paragraph 52, where he indicates this: I've read a very detailed parenting assessment. There are some points in that assessment in which I believe the mother has been unfairly criticised. And then he reaches this conclusion: I do not see, for example, any evidence of a party lifestyle as has been described. with the use of drugs save for the use of cannabis, and I'll come back to that reference in a moment. I do not see any evidence in this case, and it appears to be accepted, that there is no evidence of regular heavy drinking. I do not see evidence before me of multiple risky partners since she separated from the father, with one caveat to which I will return. Paragraph 53 goes on to say, it does seem that the mother has been able to maintain her separation from the father, and that concerns early on that she would be unable to prioritise Sebastian over that relationship have in the end been proven to be unfounded. And then in paragraph 54, he makes comment about the decision made in October not to accede to the Part 25 application for the psychological assessment, and says this, I say that because the factual matrix which was presented to her on that occasion has not, in my view, been made out, particularly in terms of the allegations of partying, abuse of alcohol, and the suggestion that the mother had failed to make any changes or maintain any changes since the proceedings were issued. Now, I'll return at a later stage in relation to his assessment as to whether that then means there's a gap in the evidence. But it's effectively continued in paragraph 57. I cannot know if the judge in October would have reached the same conclusion she did last year had the local authority not pleaded its case the way it did. Having seen the agreed note, it's clear she did place weight on the facts alleged by the local authority in concluding that the mother had made no progress since the proceedings had begun. In fact, those submissions made by the local authority appear to me to have been almost entirely unfounded, particularly with regards to partying and drug use, and there seems little doubt that the court, innocent as it may have been on the part of the advocates on that occasion, was misled by the local authority. Now, a number of criticisms are made of the fact that reliance is placed upon that finding, as we say, it inevitably must be described, in that it is suggested that on behalf of the mother, the social worker was not put on notice that it was going to be suggested that she had misled the court, and that therefore the local authority effectively were not given a fair opportunity to address that issue before the recorder. Now, if I can take you, if I may, to tab 23 in the supplemental bundle, which is, it says the mother's final statement, but I believe it was the one and only statement, and it starts at paragraph 195.
Page 195.
My apologies, page 195.
Sorry, can you just say again? It's headed final statement, but, and then I didn't hear what you said.
My understanding is it was the one and only
I see.
statement from the mother. So it's not to suggest that we've left out of the bundle any earlier statements. And there are clearly a number of times within that statement where she disputes various elements of the local authority case and their assertions. And if I can just take you through them very briefly. At 196, paragraph 7, she disputes the issue over home conditions. For example, that my home conditions are still poor, that's not correct.
I'm sorry, which paragraph number?
Paragraph 7
Thank you.
on page 196.
Thank you.
It's the third line down. And then the alcohol is referred to. In addition to this, she reports the social worker makes in relation to alcohol bottles in my bin. I think that if the social worker would have asked me about it when she saw them, I could have explained, and then she gives an explanation as to why that might be the case. Paragraph 16, and again I'll come back to this later in our submissions. She puts in to challenge the adverse information that is said to come from her own mother at the time when grandmother, if I can call her that, was responsible for having both mother and child in her home, and then also responsible for a relatively short period thereafter and looking after the child on her own, with mother visiting and having contact within the house. So she puts that into issue as well. And then paragraph 19 goes to the heart of the assertion that the local authority made in October and continued effectively in their final case. Back to that quote from their position statement: Sebastian has not been in his mother's care. Mother has been living a really chaotic lifestyle, partying, drinking and taking drugs. I've always disputed this assessment and challenged these allegations when the court was asked to consider my application for a psychological assessment, and it was explained to the court that this was disputed. Paragraph 20, the drug and alcohol testing results show I do not abuse alcohol or drugs, and I'm disappointed that the court placed significant weight on these allegations made by the social worker. Paragraph 21, I won't take time reading it out, but that's the part where she gives an explanation in relation to cannabis use, which was accepted. You'll obviously be aware from the judgment that the judge didn't accept her explanation as it is. But then paragraph 22, I'm unsure why the local authority alleges that I've been partying. The detail in the parenting assessment is vague, and I'm unable to comment on this as I'm unsure what incident is being referred to. And that position didn't change, it didn't become any clearer at any stage. I'm spending time on this now because the suggestion appears to be that on behalf of the mother, there should have been an outright challenge to the social worker during the course of the hearing that she was lying, and that in the absence of that challenge, it cannot now be fairly relied upon by the mother to say that this particular aspect of the local authority's evidence is relevant to the, if I can say, safety of the judgment that the judge made at the time he comes to approve placement orders. We dispute that interpretation. A mother is entitled effectively to say to a local authority social worker, where is the evidence for the assertions that you allege? She doesn't have to say that the social worker is being dishonest. She doesn't have to say that she is lying, but she is entitled to say, you assert a case which is simply not borne out by the evidence that exists or the evidence that you have produced. And we say that was the line of cross-examination that was undertaken of the social worker at that hearing in March. And so we're perfectly entitled to say that the finding of the judge, and it was the judge who used the phrase misled, is perfectly proper. The social worker had the opportunity to explain what had underpinned both what appears to be direct instructions from her, she was the social worker at the time of the October hearing, and underpinned the matters that were then repeated in the parenting assessment, that the evidence was tested, and the judge is entitled to say, you have not proven that element of the case, and therefore the court previously was allowed to act on erroneous, unreliable, or misleading evidence. And that's how we categorise it. We say we don't need to go as far as she's a liar. But once the court makes that finding, that a social worker has provided unreliable evidence to the court in fairly strident terms, as put in the position statement, it is then incumbent upon the judge to look at the other strands of evidence that he may feel he is wanting or able to rely on to justify the most draconian order that there can be for separating a child and its mother permanently throughout not only childhood but into adulthood.
So, as I understand from what you've been submitting, you accept that it was not put to the social worker in cross-examination that her evidence was untruthful.
Yes, we accept that. I'm sure Miss Edwards will alert me to anything I say that I've misunderstood from her role. We did not put it that she had lied to the court.
I take it, therefore, that it was not put to the social worker in cross-examination either that the court had been misled in October.
The word misled did not come from Miss Edwards during the course of either submissions or cross-examination.
Thank you. Final question on this topic. What in your submission is the recorder's assessment of the social worker's reliability as a witness?
I'm really sorry, my lord. Assessment of the social worker's reliability
As a witness?
as a witness.
Because as I understand the position of the local authority as articulated in their skeleton argument, the local authority contend that if you disregard the word misled,
Yes?
which, as you've just acknowledged, was not part of your client's case as expressed through cross-examination or submission, otherwise the local authorities say that the recorder's assessment of the social worker as a witness was that she was a reliable witness. Now, my question is, do you disagree with that? And if so, upon what basis?
Well, I think we do have to disagree with that because of the wording that I've taken you to already, where the judge himself indicates that he has seen no evidence of those particular factual assertions. And by that I'm assuming that he is indicating that he has seen no reliable primary evidence to support the categorisation for each of those allegations against the mother as being reliable. It has not come up to evidence that he is satisfied on the balance of probabilities is more likely to be true than not. But that has to be taken from what are very clear recordings of him as to the absence of evidence on those particular points, which he repeats.
Can I just explore that a little further? I understand what you say about the judge's findings as to what was a fact and what was not a fact. I take that point. But there's a separate question, which is assessment of a witness.
Yes.
And it's perfectly possible in some cases for a judge to say, well, I accept that such and such a witness is a reliable witness, but nevertheless, looking at all the evidence, I don't find things proved.
Yes. I think the only, my lord, witness that he does that exercise with is the mother. I think that's only explicit in relation to her in the course of the transcript of judgment. And so, for example, if you give me a moment, if you go to the core bundle at page 56, paragraph 51, we have 4 lines down. I consider the mother to be in many respects a very impressive individual, and then comment says face much in the way of trauma. He further on indicates why it is that he does not accept her explanation in relation to the cannabis as being effectively a prescribed way of dealing with her pain. I'm just trying to find the precise paragraph. Will you bear with me one moment? I'm sorry, I should have made a note of this. Whilst I'm still looking for that, I'm going over other paragraphs. 84, he does an assessment of the mother's evidence there, indicating that she remains overly defensive to criticism and seeking to explain why she has done things, rather than, in his assessment, seeking to learn why she should not do them.
Well, could I ask you about paragraph 94?
Yes?
Because in paragraph 94, the recorder says, I endorse the exercise that has been undertaken by the social worker as set out in her final evidence.
Yes.
So could the recorder endorse the exercise undertaken by the social worker if he considered the social worker was an unreliable witness?
Well, that unfortunately is one of the problems we say there is with this judgment, because he has clearly found the social worker, at least, matters not really what word I use, unpersuasive, unable to evidence the case, but then appears not to factor that part of it in when looking at other matters, because reliability isn't only reliability on a factual issue. Reliability can go to the way in which you come to a conclusion about likelihood of change, of assessment of risk. And we say that that was a failing in the judgment, because what he didn't then go on and do is explicitly say, having made that conclusion that the court had been misled, why it was he found her persuasive on other elements of the case. I mean, my Lord, I hope I don't stray too far from the point that you raised, but it's tied in with one of the other grounds that we say in relation to the way the evidence was dealt with, which is the apparent reliance by the learned judge on the social worker reporting the negative information that came from the grandmother and putting weight on that to assist him in his final conclusions about the commitment of this mother to the child, without in fact looking more carefully at the way in which that position is then explained by the grandmother in what appears to be, rather than reported speech, a direct cut and paste, if I can say it that way, of the maternal grandmother's information. So if we go to the supplemental bundle at page 162, the reason why I say I think it's more direct information from the grandmother, albeit still
Sorry, which
hearsay.
page did you say? Supplementary bundle page?
162, I hope.
Do you have a tab number?
It should be paragraph 8.3, views of wider family members.
Sorry, do you know which tab it is?
Give me just 1 moment.
It seems to be missing in my version.
It's the it's the final statement, I believe. 162, no, maybe the parent.
18, tab 18.
Thank you, tab 18 then. No, it will be tab 20 then. Oh, my apologies.
Tab 18 is the final.
This is the one, I'm afraid, I've marked up my
And tab
page number
20
and then taken
is
it.
the pro forma social work evidence template finals statement.
Yes.
I think you're taking us to.
So it's the statement of the 31st of January 23, which will be in your 20.
Right. This
Yeah.
is
Because
the
I
local
will-
authority social work evidence
That's
template.
it.
Final
And then
statement.
if you bear with me 1 moment, it's
Yep.
paragraph 8.3 in that. I'm afraid I took out because there were a repeat.
Don't worry, we'll get
So
there.
8.3, views of wilder family, is at 185.
Yes, got it. Yeah.
My apologies.
Could I just, my lord, just while on a document point,
Yes.
at 18 there's a tab 18. There's a final statement of the social worker.
Yes.
According to the index, that's 146 to 166, so 20 pages. but my document looks fairly complete
Is.
at 5 pages.
Yes, my lord. What happened this morning was I had noticed that those two documents, although identified differently in the index, one being the 18th of January and this one that we're now looking at being the 31st of January, the one that was said to be the 18th of January was in fact a copy of this 31st of January. So we extracted that with the assistance of all of your learned clerks and put in what in fact should have been in, which is the 18th of January, which is not the final statement.
So it's not. So that was there was a hearing in January about another assessment.
Yes.
So that was so that should be interim statement.
Yes, that effectively was
Right.
dealing with the application for an independent social work assessment, there being concerns that
Yes.
various mental health workers, as
Yes.
the mother had suggested, she may be suffering from.
So I've now caught up, Miss
Yes,
Mayor. Where
I
you're
apologise.
talking about the final statement,
We
you
were.
mean this statement at tab 20
Tab 20, page
on
185.
on the template.
All right.
Yes.
Thank you.
185, paragraph 8.3, views of wider family, and if you see 5 lines down, it starts this: my name is, and then the maternal grandmother's name appears, and I am the mother of the mother. So this appears to be something that has been extracted from a document provided to the social worker directly from the grandmother. Appears. I know not, that's the way it appears in that particular document. And so it's much more direct speech. I'm sorry, my lord, I keep cutting across.
No. I was going to say something and I didn't want to interrupt you. And I'm sorry if I seem to be doing that, Miss Mayor.
No,
The passage to which my Lord Justice Arnold took us in the judgment,
yes,
in paragraph 94, which begins, in weighing and balancing the available options before me, I endorse the exercise undertaken by the social worker. Would that be a reference, do you think, to what appears on this standard form template at
the realistic.
paragraph 7181,
Yes,
section 7, and then all the way through to 184,
yes,
where they, following the BBS line, BBS, isn't it? They're required to,
yes.
social workers are required to identify the realistic options, the advantages and disadvantages of each, and set them out.
That would be my assumption. That is how I have
So
read.
that's the exercise
Yes,
that the recorder is endorsing.
yes. But my lord would obviously say that even that could potentially, well, what could potentially is flawed if he hasn't grappled properly with the reliability of the social worker's evidence and opinion. But if I come back to 185, you can see that the maternal grandmother gives a more detailed explanation of some of the criticisms that she has made of her daughter, which were relied upon by the local authority, but also includes at 186, in the final paragraph, I would like to address the feedback comments that I made to the social worker that was identified in the court papers. Mentioned some concerns over the way the mother had handled the child. This had happened only once. I felt it was isolated, and in my opinion probably due to being tired, and had later identified that she was struggling with her mental health. I feel my comment was reported back to the courts out of context. The other comment I mentioned was that Lorna needed to be reminded on occasion to change the child's nappy. I believe this was a mixture of adjusting to caring for a newborn, being very tired as being responsible for the majority of the care of the baby, including all the night feeds, and as already identified her mental health at the time. I do believe it took her a number of weeks to adapt to the huge lifestyle change that came with having a baby at a young age. So that puts into much greater context what was said by the local authority to be maternal grandmother's criticisms of her daughter, and which were relied upon then by the learned judge in his judgment. we say, to bolster the idea that this mother would not be able, without, I think the phrase he used in his judgment, wraparound support, be able to care for this child. And yet, the positives that the grandmother put forward are not relied upon. And this is hearsay evidence, which was the subject of a debate on day one of the hearing, because it had been clear from the document I took you to earlier, the mother's statement, that she put in issue the negative comments that the grandmother had raised and that the local authority were relying upon, and yet the local authority had not produced any direct evidence of those negative features. So we say, in addition to what we say is unreliable evidence for the partying, the chaotic lifestyle, the learned judge then falls into the error, in this case, of relying on challenged hearsay evidence without hearing from the witness directly. And I know that others may say it would be for the mother to call her mother, but with respect we say not. It's for the local authority to prove their case. The mother was content and indicated to the court through her legal representative that she was content to rely on this more direct speech, and therefore it was for the local authority to seek to produce the mother to support the criticisms that were made as the mother of a carer.
So I understand what you've just said. There was no dispute over the admissibility of the hearsay evidence.
No, it's a question as to whether it's appropriate to rely on it in a case where we're looking at adoption, where it was known to be challenged, and where we say the judge himself had already raised a query as to the local authority's ability to actually prove important aspects of its case.
Right, so can I be clear what your criticism of the recorder is? Because the recorder was faced with a situation where there was no dispute as to the admissibility of the hearsay evidence.
Yes.
And neither party had called the grandmother.
Yes.
So therefore the recorder had to do the best he could with the hearsay evidence.
There were two things he could have done, my lord. The first is to indicate to the local authority that if they wished to advocate those negative comments as part of their case, they should call the witness as part of their evidence.
Sorry, on what basis can a court instruct a party as to which witnesses it's going to call?
My lord, it can indicate that the weight that it will give to hearsay evidence in the absence of the production of the witness would be so minimal as to effectively not assist the court in its task. So it can't tell a local authority you must call X, Y and Z, but there must be a consequence for the local authority if they do not provide primary evidence of important contentious evidence. Just because hearsay is admissible does not mean that it's the best evidence for the court, nor does it mean that it is reliable evidence for the court. And the fact that there appears to be, for whatever reason, a backtracking, if it would be categorised that by the respondents, or a qualification and explanation in more direct speak from the grandmother, is an indicator really that it's one of those cases where relying on hearsay evidence is unsafe.
Where does the judge and how does the judge deal with the grandmother's withdrawal or modification of what she'd said before, i.e. the very point you've drawn to our attention at the bottom of 186?
My lord, will you bear with me one moment, please? Paragraph 8, at page 63 in the core bundle.
Yes.
I note, of course, that ultimately the maternal grandmother, to a large extent, has retracted some of those allegations, although I have to note that the retraction appears to have come at a time when she was aware the local authority was considering seriously a plan of adoption. I have also remained cautious in my approach to placing weight on hearsay evidence of a witness who has not attended court to be questioned.
How, before this court, do you challenge that approach?
Firstly, there is no evidence, effectively, that the grandmother was persuaded by the nature of the proceedings to retract the information. And that is an assumption of the court, again we say not based on primary evidence. Secondly, we say although he indicates I have remained cautious in my approach, he says that, but we say he does not in fact undertake that exercise. And we see that by way of paragraph 81. The maternal grandmother, I note, also alludes to that issue in her final email. While she does accept that the mother has made improvements, Miss Watts does not retract that allegation entirely. And this is in relation to a nappy change. Now, what she said in that email was that this was a new mother, a young new mother, who took a few weeks to adjust to the new responsibilities and tasks she would have to do.
The bottom of paragraph 81, he makes a further comment about the grandmother's modification. My word. Of her evidence.
So, not retract that allegation entirely. Is that what my lord is looking at, or is there?
Yes.
Yes, that's.
So this takes us back to what was said. The final email is what is
Yes.
the passage at the bottom of 186.
Again,
to
that's
our attention.
my understanding. Yes. So we say although he realises that he does have to exercise caution about accepting hearsay evidence, he doesn't exercise sufficient caution, particularly when it's placed in the context, and we're told that we have to look at the whole jigsaw effect of the evidence, the context of the local authority having been unreliable in the allegations made against the mother in the first place, knowing that the mother had challenged this, and not hearing directly, and for effectively the local authority not to put to the grandmother that she has retracted untruthfully because she is worried about the child being adopted rather than it being truthful evidence that she gave in that email. And the court relied upon that challenged information from the grandmother to another extent, I'm reminded, in paragraph 79. It's on the same page, further up. Which is, I do infer from that a lack of commitment in line with that reported by, my apologies, paragraph 79, but on page 63. I do infer from that a lack of commitment in line with the reported by the maternal grandmother last year.
Are you making these points under your ground one?
My lord, I'm probably making them under the totality of the four grounds, but
I see.
if you wish me to go back and work through each of the grounds as individual headings, I will.
Well, no, it's a matter for you how you present your case, but I'm just trying to understand what it is that this court is being invited to do, because obviously we must bear in mind that we are not the trial court.
Yes.
We must bear in mind that we have not heard the witnesses and we have not seen the entirety of the evidence.
Yes.
It's often said in this court that we will not island hop when there is a large sea of evidence. So I'm just trying to place in context where this point is going.
The end argument, if I can put it that way, that we say all four grounds lead to, is that the proportionality evaluation undertaken by this judge cannot stand.
Yes, I see.
Because of missing evidence, unreliable evidence, an inadequate consideration of the risk that he was indicating he was defending against by approving the care plan for adoption. and the lack of rigorous scrutiny over whether in fact support could or should be given or could or should be written into a care plan which have not been provided. Because there was effectively the local authority position was that this mother, no amount of support would enable her to be an appropriate carer for this child, either now or in the future. And we say that that, again, is a flawed exercise because it can be seen, even in the judge's assessment of this mother, that there were many positives of her as a carer, and that she had, contrary to what the local authority had indicated, managed to make progress even during the course of the proceedings.
But are you saying that the judge ignored those parts of the evidence, or that he gave them insufficient weight?
Gave them insufficient weight.
No doubt you're going to come back to the whole support issue, which is really your ground 3.
Yes.
Will you forgive me if I take you
No, not at
to...
all. Would you mind if I just get a cup of water first? Yes, thank you.
And it really follows on again from the point my Lord Justice Arnold was putting to you about the final paragraph 94.
Yes.
And as I read it, I think you agreed, when the judge referred to endorsing the exercise undertaken by the social worker, weighing and balancing the available options, he was referring to what's in section 7 of her final template report at 181 to 183. And looking at the option of rehabilitation with the mother, the advantages and disadvantages are listed on page 181, and focusing in on the disadvantages of placement with mother, the social worker says, as has been detailed in the parenting assessment of the mother and statement provided to the court on 20th January, the mother is not able to meet the basic care needs and safety needs of the child. And then 2 further sentences.
Yes.
So part of the weighing and balancing was the parenting assessment, original parenting assessment,
Yes.
which you say was wrong.
Flawed, yes.
Flawed. Thank you.
My lord, I'm very sorry, I have now lost my train of thought as to where I was, but
I'm very
Well,
sorry, Miss May.
As I understood it, you were still developing ground 1 of your appeal, because ground 1 is that the trial judge failed to analyse at all the credibility of the local authority's evidence, given a finding that they misled the court at a previous hearing.
Yes.
I'm still a little puzzled as to how exactly you say that ground is made good in circumstances where you've accepted that no attack was made on the credibility of social workers' evidence, either in cross-examination or in submissions. And you met that point when I asked you the question before by saying, well, there wasn't an explicit assessment by the judge of the witness's credibility. But I'm still struggling to understand why the judge was required to assess the credibility of the social worker if there was no attack upon that credibility.
It's a question, my lord, as to, I don't want to play semantics, but it's a question as to how we define attack. The cross-examination was that the social worker had failed to produce evidence to support the assertions that she made and which were relied upon both to effectively oppose the psychological assessment that was being sought, but also relied upon as part of her assessment as to why this mother was unable to meet the basic care needs of this child. So it is an attack on the underpinning of the local authority case. If there is no evidence to support some very serious allegations, that must call into question, even if it's not a deliberate attempt to mislead the court, the reliability of the evidence proffered by the local authority, and must call into question the sustainability of their assessment of this mother as not being able to care for this child, because it is based on a false presumption. So I suppose I quibble with the idea that the manner in which the mother's statement identified the challenge and the manner in which that was rehearsed with the social worker in oral evidence is somehow not an attack on the reliability of the evidence of the local authority. And the only witness for the local authority was the social worker.
All right, thank you. And you were relying in support of that argument upon the position with respect to the maternal grandmother.
Yeah.
And you said the two aspects tied together, and could you just help us on that aspect of your case?
Yes.
Because I'm a little struggling to understand at the moment exactly how you put that, because so far as the local authority's evidence was concerned, what you've shown us is that the final witness statement from the social worker recited verbatim the maternal grandmother's qualifications.
Yes.
So how does that support the submission that the local authority's evidence was unreliable?
Because the judge chose to pick out the earlier reported negative comments and opinions of the maternal grandmother over and above that more direct evidence, in the absence of oral evidence from the maternal grandmother, or indeed a statement qualified as to the truth.
To be sure, so I understand that submission. That is a submission to say that the judge's reasoning was flawed.
Yeah.
But why does it support, as you were submitting did, the proposition that the local authority's evidence was either not credible or unreliable?
My lord, yes. We say that where the learned judge has already found fairly strident assertions by the local authority as to fact to be unreliable and to categorise them as misleading an earlier course, when you then come to test the social work position as to the grandmother's complaints about this mother's care whilst she was in their home, her lack of commitment, her lack of proper attention to the most basic of needs such as a nappy change, that the court is effectively again relying on information from the local authority that in the light of that retraction email is unlikely to be properly reliable evidence.
Does the local authority, does the grandmother's assertion feed into the local authority evaluation?
the negative comments rather than the
Yes,
retraction.
does it feed into the evaluation? Because on the form, as my lord's pointed out, what the social worker's done is seemingly recite verbatim what the grandmother had said, or not verbatim, paraphrased fully what the grandmother said at various stages. Where did the grandmother's comments feed into the evaluation?
Well, my lord, what we start having difficulty in understanding how both the evaluation of the local authority, the reliance upon it by the learned judge, and the learned judge, if he has conducted a separate exercise himself, evaluation, is that we see very many limbs of the local authority case effectively being undermined or put to one side. Because not only do we have all the matters I've drawn your attention to in terms of no evidence to show, not only do we have this retraction, but we also have a whole host of positives that he has identified in this mother's care, which do not then seem to fit with the ultimate conclusions, when taken as a whole, that this is a child whose interests can only be met by adoption. And so I'm afraid it's not a direct answer. If we look too much in isolation at each individual thread, we lose this overall picture, which is that my lord, we would say it's not little islands, it is major elements on each part of the local authority case that are either not proven or undermined or have a question as to their reliability. And that surely must mean that the local authority evaluation therefore becomes one of assertion rather than one underpinned by evidence.
For my part, what I'm looking for here, if I may say so, is evidence that the local authorities, and using words like misleading or is unhelpful, the wrong evaluation of the local authority, mistakes by the local authority, continues to feed into the local authority's evaluation, which is accepted by the judge and therefore contaminates the judge's analysis of the advantages and disadvantages. So it's a very long-winded way of putting it.
Yeah.
But that's how I've sort of understood your case. It's not how it's put on ground one, right?
No.
Which focuses on credibility.
My lord, part of the difficulty is when we come to that evaluation paragraph 7 at 181, the justification under each of them is not in fact detailed sufficiently to understand precisely what limbs the local authority then continue to rely upon or assert. Because if we look just find it's in the other version bear with me just 1 moment, please. My lord, will you
Yes,
bear me
of
while I
course.
just... My lord, if we go back to the parenting assessment at page 121, we can see at the top of that page, in fact, if we start down at 120, of the maternal grandmother are relied upon in the parenting assessment. So at the 120, whilst the child and mother resided with the maternal grandmother, it was noted again maternal grandmother had to prompt mother to care for the child. This became more apparent when the mother attended contact. And then at the top of the following page, maternal grandmother also initially praised Miss Griffith a lot, and it goes on to say, however, it got to the extent, and my apologies, that maternal grandmother did not say that the mother could competently and consistently meet his basic care needs, and that's what she appears to be responding to when it comes to that email. And so when we look at the final evidence at page, and I hope I've got this page reference right, 174, we see again issues being raised as to when mother went to reside with maternal grandmother, which is the 4th paragraph down.
Yes.
We see the comment in relation to relationship choices. This is less maternal grandmother, but still the other parts of the local authority evidence, chaotic lifestyle.
Which paragraph are you on? Which page are you on now?
It's the final paragraph at 174 going over to the top of 175. So
Yes.
this is within
Yes.
the analysis of risk and protective factors. And it is difficult to understand how it is that the local authority, in, for example, at 175, little paragraph 4.1 under the child impact analysis, paragraph 3, of how the local authority come to those conclusions when we feed in the critique, the attack, whatever we've already done in relation to the elements of the evidence that might otherwise underpin that. Because it's indicated, for example, she's also at risk of failing to attend to her son's needs. Now, the isolated, we say, I'm not going to minimise, for example, the June incident where the father came to the home and was violent and an altercation occurred and the mother had to be told by the social worker to remove the child from the situation. But they have become very isolated descriptions. If we leave out of account what we say is the unreliable evidence as to the chaotic lifestyle, partying, risky partners, alcohol, if we leave out of account the retracted allegations from the maternal grandmother, they become very isolated pieces of information that then appear to be what is left to underpin that balancing exercise, the BS exercise at paragraph 7, which is then adopted by the judge below. And also, for example, there are critical comments made by a supervisor in contact, effectively, which were identified by the learned judge below as matters that he fed into the equation. those being mainly from the course of one contact in relation to the mother giving the child a wet wipe, a water-based wet wipe to suck on while she was doing a nappy change. A mother on a separate contact indicating that she had given the child a drink from an adult cup, when they do not, in our respectful submission, appear to have been persistent failures borne out by the remainder of the contact recordings, which the judge in his judgment indicated the local authority placed a great deal of weight on, but as far as he was concerned, and I don't want to misquote him, but it was words to the effect that they were overwhelmingly positive. So that's paragraph 82 at page 63 in the core bundle in the judgment. And we say that when it comes to the necessary analysis to justify adoption, that there is insufficient weight given, as there has been in other cases in the past, to the consequences for a child of not being a member of its birth family or having the opportunity to be brought up by its mother. And that the risk element, which is used to justify the removal, is not either properly identified as to precisely what risk it is that it is said this mother poses to her child in the future, that could not be addressed or supported or assisted with some proper support plan. Within that we would include education, training, elements of supervision, community care plan that involve not just maternal grandmother who takes over care, but a whole network of family members. So maternal grandmother, the maternal grandfather, the parents of her current partner. And we say that therefore that BS exercise in paragraph 27 is improperly carried out, gives insufficient weight to the counter factors of removal, and that the judge is therefore wrong to rely upon that in the paragraph that my lords have taken me to at the end of his judgment.
Now, that last submission, if I may say so, is really encapsulating ground 3
Yes.
in the appeal. Now, can I ask you about what was said in the skeleton argument by Mr. Maynard in the core bundle at pages 118 and 119, where he addresses ground 3. And he submits that from the notes available from first instance, paragraph 26, in lettered paragraphs A to E, without reciting them all, the gist of it appears to be that no questions were put to the social worker about alternative support packages or plans, and no evidence was adduced, for example, as to how a community support package would be structured.
Yes.
What's your submission in response to that?
Obviously these are matters that I have raised and Miss Edwards has assisted me with. And again, I rely on her to indicate if I misstate any of the information in relation to that. The questioning of the social worker explored, in general, whether there was anything that she could recommend by way of support, and challenged the social worker on the fact that she had not directed the mother towards any particular areas of assistance. Submissions were made about the idea that no support package or plan was advanced by the local authority. And so it's right that a structured alternative package setting out all of the elements was not put to the social worker. But the general thrust that the social worker had not provided proper thought or steps towards assisting the mother and setting out an alternative care plan was put. I just want to check that there is nothing else that Miss Edwards would like me to raise in answer to my Lord's question. In addition, what was explored with the social worker was that there could be a plan of community contact to see how that in fact worked. That could be something that then led to a placement at home, initially supervised either by a family, a member of the family to support, or by other workers. And that could then increase, effectively leading to part of a community type assessment in a rehabilitation home. And there were submissions made about the role that grandmother, grandfather might be able to adopt. But other than the signposting, which his lordship, my apologies, which the learned recorder commented upon further in his judgment, and I want to find where he says it first before going to the end of the judgment. Bear with me just one moment. I think he was a degree critical that in fact the social worker, having made a recommendation within her final evidence that the mother would need to do a parenting programme, or could do a parenting programme, then herself was unable to identify precisely what it would be that type of support would be geared towards. And again, I apologise, I just want to find where that actually is. Paragraph 87, page 64 in the core bundle.
Yes.
Maybe said the mother needs to do further work. Certainly the parenting assessment concludes that she needs to go on a parenting programme. I was somewhat critical and remain somewhat critical that the social worker was unable to put her finger on any particular type of work that might include, but ultimately did explain in her oral evidence the concern was not that the mother lacks parenting ability per se, but she lacks the ability to do these things consistently. And then what is of note in relation to the learned judge's approach to the idea of this parenting deficit and the idea of support that might be provided for it is paragraph 96 of the judgment at page 66. I do, however, make one final plea. Maybe some time to go between placing the child for adoption and finding an adoptive placement. Within that time, it is clear to me that the mother should still be offered support to both maintain what improvements she has been able to make and to make further improvements. She's a very young mother. There's a good and high probability she will have children in the future. I would ask in those circumstances that the local authority continue to engage meaningfully with her, and that the recommendation made in the parenting assessment that the mother engage in a parenting programme be one that is taken on in a meaningful way, and that referrals are made. I think it was part of the social work evidence that those referrals have not been made up until that point, and the mother assisted to improve in her parenting skills. I also make a plea directly to the mother. She has made progress. She has listened to things that the local authority have said in several regards. I would ask that she make all efforts to continue in that vein, and that she continue to work with her treating clinician, and she take up any offer of work that the local authority is able to provide her with. And that doesn't seem to sit squarely with an assessment by the judge that this mother would not be able to learn skills, would not be able to follow the advice. And if there is that assessment by him, then we say that supports the idea that the time had not come to a conclusion that this child's best interest could only be met by an adoptive placement. And that therefore that termination, effectively, of the relationship has again been done on less than robust assessment and balancing of the pros and cons for the child. My Lords, I'm conscious that one of the matters that I haven't expanded upon at all is the application for the psychological assessment.
Yes.
It's been put in writing. I'm also conscious as to how long I've been taking. Could we put it this way in relation to that assessment? We find it odd that the judge relies on the fact that the mother asserted that there wasn't anything that she thought she might need that would flow from a psychological assessment. Very often assessments under Part 25 are ordered by a court when there is resistance or a lack of insight or a lack of understanding on behalf of a parent. That in itself should not preclude the fact that a psychological assessment, or indeed any other independent social work assessment or psychiatric assessment, might not assist all in the case to reach the right balance. Part of the problem that we say would be addressed with the psychological assessment is knowing in fact whether some of the more risky behaviour that the judge relied on, his suggestion effectively, but we have to balance it with the idea that the mother had managed to separate herself from the father, had not hit that relationship with the father over and above her relationship and care for the child, despite the pessimism about her being able to achieve that, but might assist the court in understanding the cause for what the court identified as being risk of sexual exploitation and risk of taking on needy partners. You're aware of this mother's particular background. It's set out in the documents and in the judgment, and it's quite clear that there are certain elements of her background that may feed into that type of behaviour, that may, if properly assessed and given proper expert opinion as to what assistance could be given, what packages there might be to assist the mother to move away from that behaviour if it is accurately assessed. So, for example, cooperation between children's social worker, mental health social worker and adult social worker, all of whom the mother effectively was entitled to and the child was entitled to the child's social worker, how they could all work together and cooperate together to put together a package that would support this mother in caring for her child. The social worker had commented, I think both in her initial statement and in the parenting assessment, she effectively was not an expert in understanding how the mental health aspects that related to this mother might impact upon her ability to understand. And then you've got that 5-page statement that deals with how the social worker approached the mother, a suggestion that that was sufficient to deal with any query that she may have an autistic spectrum disorder or ADHD. My lord, I could see that you wanted to...
I just want to know what the reference was for that. You say, if you could help me, where do the social workers say that in terms of the point you just made?
The term about not being an expert.
Yes.
My lord, will you just bear with me one moment, because I have it in my notes.
Well, to come back, very convenient.
So, my lord, it will be supplemental bundle 110. And it's the final paragraph on 110 over to 111. It's not within my professional expertise to fully understand the potential impact of the mother's current circumstances and its potential impact on her decision-making ability. However, what is clear from the discussion with the mother is that changes in her life can influence changes in her mental health and result in its decline. And then we see at 111, the final paragraph in that box. The mother has experienced extensive childhood trauma, is currently experiencing the trauma of being separated from her son. These will no doubt have contributed to her ability to make decisions. So it's understanding and unpicking those sorts of things, and then in the parenting assessment also at page 100, it's in fact the same point that I just raised. Give me a moment. In the initial social work statements of the July 22 social work statement, which I hope is at supplemental bundle page 40. At that stage it's a comment in relation to both parents. The mental health presenters is in the middle of the page. Presenters complicating factors, as at this moment it is unclear how this would impact upon their ability to meet the ongoing needs of the baby consistently. So on those elements that then are left to underpin the judge's acceptance of the local authority balancing, we say that there is a gap in the evidence, and that is an expert report to assist in understanding why the mother might do certain things that the judge has found as being inappropriate and potentially being a risk, and how they can be ameliorated or mitigated, and that those are things that it's necessary for the court to consider before taking the step of saying adoption. And with respect, obviously it's been asked, well, if there wasn't a specific package that was put to the social worker in terms of support, effectively how can that mean that the judge was wrong to rely on that? Yes, there is a duty on the advocates before the court to make sure that attention is drawn for the judge to the relevant steps. But again, it's the local authority to prove the case that only adoption will meet the welfare of the child. They have to do that with a proper consideration as to what support might be possible, is available, or potentially could be put together. And at the end of the day, also the court has its own duty, particularly on the proportionality exercise at first instance, to make sure it also considers that aspect of the case and to call for additional evidence. For example, to invite the local authority to file a different and further care plan, setting out aspects of support that could be put into place for this mother and this child.
But could we just go back to ground two, which is what you were addressing?
Yes.
And your starting point there is, you say, well, the judge himself recognised that there was an evidential gap. And so you say there was therefore a clear and identifiable gap in the evidence, and he was wrong to say that that didn't require further assessment. But can you help me on this? And I'm sure this is my ignorance arguments about family court procedure, but I'm a little puzzled as to how procedurally this works, particularly given the way that it's put in the skeleton argument for the appeal, because consistently with the appellant's notice, what you're asking us to do is to allow the appeal and then remit the matter
Yes.
for rehearing before a fresh judge. And
Yes.
I completely understand the logic of that. That's pretty clear. Then the last paragraph of your learned junior's skeleton argument says that the mother will seek to pursue her application for an expert psychological assessment. Now, that then leads me to two related questions. One is, this seems to involve a lot of delay. And it may be that there's no way around that. If a flawed assessment is undertaken first instance and there has to be a retrial, well, there's inevitable delay, and that's unfortunate, but that's life. That I can understand up to a point. But what's puzzling me is this. First of all, it remains the case that Judge Bujaja's order is unappealed.
Yes.
So, question one is a rather elementary question. How do you get around that? But then question two, which is perhaps more important, is you seem to be envisaging that you still have to make an application for an expert psychological assessment, which seems to involve an acceptance that even if this court allows the appeal and directs a rehearing, it's not necessarily going to be the case that you'll be allowed to have that expert psychological assessment. And that seems to me to be a bit of a conundrum at the moment. But as I say, that may be just my ignorance.
If I can try and work through those, my lord, in relation to effectively categorised as a case management order, the rejection of the Part 25 application for a psychological assessment. Parties are obviously able to launch an appeal against a case management order. However, it's a very stringent test to do so. And in this particular case, the case management order was not appealed because what effectively had been determined by looking back at the previous judge's note is that it was refused on the basis of an assertion of case for which there was, even at that time, by that judge's determination, no primary evidence. Directions were made for primary evidence to be filed, and I think it highly unlikely that had a case management order with those directions been appealed, that it would have got any further than saying, well, isn't the right thing to do to come back when the next judge has that evidence and the application is considered again. So I think the fact that it is unappealed, in my respectful submission, it is not a point against the mother being able to raise that application again. It's not a point against the mother being able to make that application again because in children's cases, evidence is not static. Things also change. Further information is brought to light, and therefore a review of earlier case management orders is entirely appropriate. That's not to say that it would necessarily succeed, but it's not necessarily a one-off, you've had your chance, you cannot renew that application.
Okay, so that's a clear answer to my first question. What then about my second question, which is, even if we allow the appeal, you seem to be accepting there's no guarantee that the mother will be able to get an assessment.
Two ways of dealing with that, my lord. The first is, my understanding is that this court is enabled to give any directions that the lower court might do, and so if this court felt that a psychological assessment, Part 25 assessment, I'm going to be challenged on that, but that is my understanding, then if this court felt that it was appropriate, they could give a
You're not asking us to. Neither in your appellant's notice or in your skeleton argument do you say, please make an order for an expert psychological assessment. On the contrary, there's an acceptance that there will be a future application to the lower court.
My Lord, if I can put it this way, I think it would be more normal that if a case is being remitted to be retried, then it is usually again that trial judge is the one who would be seized of the application.
To be sure, which is the logic of your
Yes.
original position.
Absolutely. But I don't, although I can see my Lord is looking at me, I don't rule out the possibility that this court has the powers, should it seek to do so.
I share my Lord's slight amusement about the way this point is, how it's being developed. You, Miss Edwards, as I understand it, sort of renewed her application.
In front of the judge.
In front of the judge. I say sort of. Please, I hope she won't. That's not intended to be a criticism. But it wasn't. What you haven't mentioned, and of course the reason I reached for the Red Book was to remind myself, is that there are quite strict procedural requirements for applications for expert evidence in the family court under Part 25.
Yes.
Because of lots of criticisms of cases in family cases where there were too many experts being applied for without rigour. So now there's a rigorous process. Now, there wasn't another application.
There wasn't?
Under Part 20. The original application to Judge Brigea was under Part 25.
It was.
There was no further application made under Part 25 to the recorder. But, I'm right.
There was no fresh Part 25
application
formally.
Although Miss Edwards did, her principal case was the case you couldn't make a final order, shouldn't make a final order without having an assessment, therefore there should be a further adjournment.
Yes.
Right.
And I think also the judgment records that no party effectively took issue with the fact that the procedure of issuing a fresh application had not been made.
Now you haven't got any Part 25 application here today. And Part 25, amongst the rigours it imposes, is you have to identify the expert, name the expert with a timetable clearly
My Lord,
sorted out.
can I just take it a stage further in relation to what happened in the court below? So not only was there that made as part of the submissions on behalf of the mother that there should be an adjournment to enable a further assessment, the court indicating that nobody stood on the formal rules of issuing a fresh application. When the judge retired, he also asked for information to be provided as to how long any such assessment would now take. And that's why you see in the judgment that he refers to the fact that he was told that it would be 4 weeks.
Yes.
Although he
I was wondering about that. That's where that came from.
That was, he specifically invited those representing the mother to provide him with information as to how long it would take, should there be a direction for an assessment at that stage. And one of the other formal matters, obviously, that there needs to be in the Part 25, as you rightly indicated, is identification, and I believe that there was a specific worker identified that the 4 weeks had come from, and the letter of instruction effectively would be the same letter of instruction as there had been previously.
Well, what is the position now?
My Lord.
If as my Lord says, your course is that you invite us to allow the appeal and remit the matter to a circuit judge to decide whether or not there should be a further psychological assessment. So at that point, a Part 25 application will be made. Is that
Yes.
right?
Well, a Part 25 effectively will be issued as soon as if the appeal is allowed. And it will have to contain all of the information that it would normally do with the identification of workers and timescales. That letter of instruction would need updating, but not by a great deal.
But a material part of your appeal, it may not be the only element of your appeal, but as I understand it, a crucial part of your appeal is that no final decision can be taken about this child's future fairly until the judge making the decision has the necessary information on both sides equation. And without a psychological report, that wouldn't be available. That's your case, isn't it?
It is
One of your case, one of your arguments.
part of the case,
Yeah.
yes. It's a strong part of the skeleton argument.
That's ground 2.
It's ground 2 linked and linked into 3 as I read it.
But as I say, it's all linked together.
Yeah.
And obviously, we are in the court below's hands as to whether that is in fact the information that it feels that it requires.
Well, you say that, but at least as I understand your ground 2, actually, if ground 2 is made out, there's only one answer
Yes.
that can be given to that question, because the whole basis on which your appeal would have succeeded on ground 2 is that you cannot properly conduct the proportionality assessment which the law requires you to conduct in the absence of a psychological assessment. Is that fair?
If ground 2 is made out,
Yes.
obviously we still say that the appeal potentially
I understand.
is strong enough to
It's
succeed.
not the only ground, I do understand.
Yes.
But it links into ground 3 as well, because ground 3 is, the judge is on the question of support.
Yes.
And isn't it part of your case that without the psychological report, the judge couldn't evaluate what the level of support could and should be? It's not the only element, but it's a crucial, it's an important element of the support package. To what extent was the mother, could the mother be helped to, you mentioned risky relationships. Could the mother be helped to avoid risky relationships? That's part of the support package which you say would have to be evaluated before, as a part of the process of comparing the realistic options.
My lord, yes. Although obviously, as I've said, children's cases aren't static. It may well be that there is additional evidence available less than a psychological assessment that actually demonstrates that the mother has been able to in fact deal in a much more successful manner with that part of her life in any event. Not only has she separated from the father and maintained that separation, but she is in a stable relationship. And again, the updating of information will feed in to the assessment of necessity. But yes, it has been a key element of the mother's case in October, in November, and as part of the appeal.
May I just ask one further point? Just going back to what you told us about the information that was given to the judge.
Yes, about the time estimate.
So the judge was given information informally, really. It wasn't
I think it may have been a request and an email.
okay.
So I think the request was oral. I'm just looking at Miss Edwards, and it was responded to by an email with the details of 4 experts. Can I just check whether all of them were giving a 4-week time estimate? So I don't know whether my lord's heard that. So of those 4 experts, one was giving a time estimate of 4 to 6 weeks, 1 6 weeks, 1 6 to 8 weeks, and 1 10.
Okay, and how was that information conveyed to the judge?
Email.
So he was given an email with all that on it,
Yes.
effectively, forwarded to him. So that was really evidence he had, was it?
Evidence in the sense of it was information that had been ascertained by those acting on behalf of the mother, that all of the parties were copied into that particular email. It was invited by the judge, and it is the same amount of evidence as you would have on a Part 25. We have been told by these identified experts this is the time that it would take them to do the report.
So then, again, following my lord's point, why couldn't you be asking us to order a psychological assessment on the basis that there was information before the judge, which, even though it didn't comply fully with Part 25, complied materially with the requirements of the rule?
My lord, yes, and I'm sure inquiries are being made also as I'm on my feet.
It seems to me that what you're really challenging under ground 2, and I appreciate it's not the only ground,
Yes.
but focusing on ground 2 for the moment, in substance what you're challenging is a case management decision by this judge. Never mind what the judge back in October had decided, because clearly this judge was of the view that he could adjourn. And he deals with this at paragraph 93.
Yes, he
of his
makes it
judgment.
one
Yeah.
of the 3 options.
Yeah, so what you're really doing in this part of the appeal is saying that he was wrong in refusing that adjournment.
Yes.
Now, as it seems to me at least, logically, that amounts to saying that there was only one answer that could be given to that question, that a psychological assessment was required. It wasn't simply a matter for his discretion, that the conclusion to which he came is one that was not open to him. If that's right, then if we allow the appeal on this basis, then, as it seems to me, you are in substance asking this court also to say, because you wouldn't be saying, well, this can be left to the discretion of the lower court on remittal. You'd be saying there's only one answer that can be given to that question. Is that right?
My lord, I accept that, yes. And as I say, I'm sure if time allows that we may at least have set in training inquiries, if not receive some answers, to be able to give information as to timescales here as well.
I'm conscious that the court has had a lot of questions for you, and I'm very anxious that you should have the opportunity to have completed your submissions as you wish to make them on behalf of the appellant. Is there anything else that you would like?
Again, my lords, will you allow me to turn my back? My lord, the only thing I think I would like to effectively remind the court of from our skeleton argument is the number of positives that were identified on behalf of this mother. And some of those positives are not easily achieved. So where there's criticism of a mother as to not having insight about the impact of domestic violence or taking a little time to report that, the success that this mother has had in keeping herself separate from a violent partner is actually something quite constructive for this mother. And the positive nature of her relationship with her child, and there's no question, it said that she clearly loves him and that's accepted, and those overwhelmingly positive contact recordings. And if we might just invite your attention at an appropriate time to the contact that was a contact that the Guardian in fact attended, which has been included within the bundle, and I think, let me just check, it's in supplemental bundle page 192. In fact, it starts at the bottom of 192 and goes over to 193. And we would invite you to consider that, because it's all well and good for us to say, effectively in a very stale atmosphere, the contact recordings are positive. But sometimes it does assist, and I know the mother would feel appreciative of it to actually see her relationship with her child. There were many contact recordings. All we've done is taken the two that the judge relied on as negatives and also provided two others to indicate that they are good examples of how this mother is with her son.
Thank you.
Can I assist you any further?
May I just check if my lords have any questions?
Thank you
That's
very
been
much.
very helpful. Thank you very much. Yes, Mr. Collins.
My lords, my apologies for the delay this morning. Circumstances were outside of my control. I'm grateful for the time allowed. My lords, you have my skeleton argument. I have seen Mr. Maynard's skeleton argument on behalf of the children's guardian. I agree with that. I don't endeavour to repeat myself for the matters that have been set out in those matters. With your permission, I would just wish to address some of the points that have been raised in all submissions, and deal with any of the matters I can assist. Firstly, if I can deal with the issue as to the quality of the social work evidence arising out of the court's determination as to the local authority having misled. My lords, you've seen what I've said in terms of how that decision is reached, and effectively my position remains as per the skeleton, is that this is a situation where the court has determined the local authority has not proven various elements of its case. but that is not to say that it had been wholly wrong. So one of the concerns that was raised was the issue that there was drug use. There's cannabis use. The judge dealt with that matter. One of the issues that was raised as to part of that, and this is dealt by the judgment at paragraph 63, that's page 58 of the core bundle, is to deal with the fact that the hair strand testing failed either due to mother's naivety or a deliberate attempt to frustrate that testing by way of dyeing the hair blonde. So there was evidence of concern. The judge didn't go on to make the determination that the local authority sought. As to the use of alcohol, the judge recognised that there was issues as to the concerns that were raised by the local authority, and that in particular being the rum bottles in the bin when the social worker visited, but did not go as far as the local authority is concerned of abusing alcohol. And so still points out that the mother is minimising the extent to which she drinks recreationally. The judge further deals with the issue of chaotic lifestyle at paragraph 70. My apologies. Apologies, I've missed that. I've just mislaid my reference.
Well, I think it's 74, isn't
I'm
it?
grateful, yes. And again, he clearly goes on to find that the local authority's characterisation as chaotic is inappropriate. But, and I'll tie back this to the issue as to grandmother's evidence. In 75, he goes on, the core criticism, which the mother did not deny, was her inability to fully commit to her son.
Sorry, where's that?
75,
Oh,
just over the page at,
yeah.
at 62. So, in effect, I say the caution has to be taken as to the characterisation of the local authority's evidence as having misled. I've set out, this is not a case where this judge has said that the local authority social worker has lied, that the local authority social worker has known this not to be true, and set out otherwise. Local authority social worker has set out her evidence to support the basis of her allegations, and this judge has said, I don't find the height of what's asserted to be proven.
Well, for my part, if there's any suggestion of bad faith by the social worker needs to be completely set to one side.
Great.
The social worker made information was put before the judge in October, based on the social worker knew at that point, or thought she knew at that point,
Yes.
which turned out to be wrong in
Yes.
some respects. And professionals make mistakes all the time, inadvertent mistakes. Is the use of the words misled or anything like that. If there's any criticism of the social worker, then that's not relevant.
No, I'm grateful.
The question is whether the mistaken information infected the decision-making process.
Yes.
And the case you have to meet, it seems to me, is that it did at 2 points. First of all, in October, when it led the judge to refuse the psychological assessment, and secondly, that it continued to infect the local authority's evaluation throughout the process, up to and including the balancing exercise at the end.
My Lord, I entirely agree that is the consequence of the impact of the court's finding, but I don't agree that it infects the local authority's evidence.
Okay.
And crucially, that's set out, and I think even more fundamentally, I should say, is set out that in terms of the judge's decision, he has very carefully analysed the available evidence as to the concerns that lead him to reach his conclusions. And so it's not just a case of he was aware that he was clearly aware that he was concerned as to the local authority had got aspects wrong. So that must have been in the judge's mind when he was undertaking his analysis. And then he goes on, I say, to detail the relevant concerns, which are, I've set out at length, I'm not going to repeat them all, as he set them out at length, because they do tie in to the point that he sets out in the analysis, is that there are concerns as to cannabis use, there are concerns as to the mother's ability to protect, and fundamentally concerns as to mother's basic care of the child. And that's the court's analysis with the evidence that he had available to him, not just from the social worker, but the analysis that he had from assessing the mother in her evidence, as well as the contact records that were provided and understanding those matters therein. And so I say, A, no, the local authority, just because it was wrong on some aspects, does not make it wrong on every aspect. But in any event, that even if the court were to be concerned by that, this judge has rightly gone on to analyse the evidence that is available and form his own impression as to the relevant concerns and the balancing exercise in respect to this child's welfare. I hope that addresses the point, my lord.
Thank you.
But that does tie in, I suggest, as to this point as to the grandmother's evidence and hearsay. The earliest point that the judge reminds himself that this is a problem is certainly at paragraph 75, page 62 of the core bundle, where he commences that paragraph with the maternal grandmother's evidence I entirely accept as hearsay and recognises the issue. What the judge then, I suggest, does from paragraph 75 for a large number of paragraphs, all the way down to paragraph 81, is go through the elements that cause the judge concern and fundamentally links those to elements that are either not in dispute or other evidence that is available. And so it's not a case that the judge has only taken the hearsay evidence that's available. He's recognised that hearsay. And for example, in paragraph 75, he gets down to the core criticism of the grandmother and says it's not in dispute, and that's the finding he makes. He goes on at the end of his analysis as to maternal grandmother at 81 to say that the issue is the mother's day-to-day ability to meet the basic parenting needs consistently, that being the very last sentence of that paragraph.
Sorry, which paragraph?
81.
Thank you.
At 63.
Yeah.
And then the judge immediately goes on to his analysis to see what other evidence there is that corroborates what he has recognised as hearsay evidence. And fundamentally then goes through the contact records, and then the judge reaches his own conclusion, having also considered what the social worker parenting assessment was at paragraph 87, which starts at page 64 and goes over to page 65, including criticisms of the social worker he makes. And in terms of balancing that exercise, he reaches his conclusion at paragraph 89, which is page 65. Taken as a whole, I find the mother is not able to provide good enough care. And I say that is the right way to approach a situation on behalf of the local authority when you are faced with hearsay evidence, because the judge has not taken it in isolation. He's not sought to rely upon it as proving facts, but as the context that he's been provided, and then sought to identify whether there is primary evidence which assists him in understanding those matters and extracted the key elements. He is, of course, entitled to rely on hearsay evidence. It's a balancing exercise as to its weight, and I say it's very carefully undertaken in this judgment.
How does he resolve the contradictions in the hearsay evidence, the grandmother's retractions or qualifications?
Well, I think
how does he resolve that?
My lord, I think he resolves that. Firstly, by recognising there are contradictions, but fundamentally only focusing on the concerns that have been raised that are subsequently evidenced in primary evidence. So again, paragraph 75, he recognises there are the contradictions and then says halfway through the paragraph, I note that the maternal grandmother's core criticism ultimately, which the mother does not deny, has been the mother's inability to commit fully to her son. The maternal grandmother's criticism in that regard seems to be borne out. So I suggest the judge has clearly got in his mind what are the relevant elements of that evidence and how they tie into the holistic analysis that he has. He has not fallen into the trap of considering the hearsay evidence as proving facts in of itself. It's a picture which he was obliged to look at and rightly balanced as part of it. So I suggest to this court that ground of appeal is not made out as to a reliance on the hearsay evidence. Points have been raised as to the point of the support package. Firstly, I raise concern as to the reasonable suggestion of a community support package, of community contact in this context, when the court, and it's the same paragraphs we've been through in respect of paragraph 81 onwards, as to basic care, that there are significant basic care concerns within supervised contact that requires intervention. So that, I'm not aware from the notes that was mentioned, but even if it was a matter of advance, one can clearly see there are immediate difficulties with it. But the support package analysis generally, I would suggest the judge has undertaken a detailed and careful consideration about it. This isn't a case akin to Reedy. This is not a case where you have a parent with significant learning difficulties that have a cognitive ability that precludes them from understanding what's happened. The judge at multiple times references intelligence of the mother and her ability to understand. So the fact that her evidence is also that her mental health does not affect her parenting, that she does not understand what support, she does not propose there is a need for additional support, and the fact that the local authority at the hearing accepted that there was not a risk presented by her mental health per se. It is the other aspects of the case that were relevant.
But there's more to the psychological component or issue than intelligence and mental health. She has, I don't want to spell it out, but she says have personality disorders and other features which would have been covered by the evidence that's not there because of the gap, as the judge found.
Yes.
So,
no, I apologise. My point.
So, if we're thinking of the discipline which you will quote, various judgments, you have to identify what the level of the support is needed. That's the first stage. Then identify what the local authority or any other agencies can do to meet it. And thirdly, decide whether in those circumstances the child's welfare needs will be met. Assuming that discipline applies here, in the absence of the psychological report, the evidence gap, how can the judge identify what level of support she would need?
Well, my lord, that was available to the judge by virtue of the evidence as to mother's mental health, Dr. Panatharia's evidence, and the mother's evidence. Her mental health was stable. She was receiving treatment, and there were no concerns as to her ability, and that did not itself present a risk.
Forgive me. There's more, as I said, there's more to the psychological component than mental health and intelligence.
No.
The fact that her mental health was stable did not obviate the need for a psychological assessment. That's the argument.
But I disagree, because the issues within the case are the mother's mental health. There isn't a suggestion, aside from those matters that have been raised, that a psychological assessment can address any other matter.
Well,
it's her personality disorder, which is a diagnosed personality disorder, and her anxiety, and those are matters that are being treated. And so it is unclear, and I would suggest a psychologist to what degree can that assist the court in making a determination as to whether the support package available whilst the mother is being treated and is stable. What further help can possibly be identified when she's in a position where that doesn't affect her ability to care?
Can I ask you, if my lord had finished on
Yes.
that topic, can I ask you about paragraph 87 of
Yes,
the judgment below? Because this is in the context of the possible need for a support package.
Yes, my lord.
And what the judge says is that the big concern is not that the mother lacks parenting ability per se, but that she lacks the ability to do these things consistently. The issue, therefore, is not necessarily teaching the mother the basics, but ensuring that she's able to implement those skills on a consistent basis. In the social worker's view, there is not a course that could address that particular issue. She was at a loss to recommend what she could recommend in such circumstances. I'm just wondering whether that's relevant to your submissions.
But it is, my lord, and I deal with it in the skeleton argument. The point is that this is not a case where a support package can remedy the problems with the parenting. So there are many cases where there may be a parent who is incapable of providing an element of parenting, and there is a training course they could do that may assist them in resolving that issue. In this particular case, the evidence is the mother is able to do it. There's no need to train her in the aspects that are missing from the basic care. It's her implementation that's the difficulty. And in the absence of that, there is very little a professional can assist a parent in order to do that consistently. I'm certainly, and that's the evidence done before the court and what the judge accepted, that there simply isn't a course that remedies that. So in terms of support package, there's that element, and then of course there is the judge's findings that the mother wouldn't engage in the support in any event, that she had declined the support from adult services, that she expressed in her evidence that she would not undertake the freedom programme again.
Yeah, the way he expresses it is serious doubt.
Yes.
End of paragraph 89. One of the things that's been submitted on behalf of the appellant this morning is that there were potentially other things that could have been, should have been tried, and the judge didn't deal with them. I think the point was made about that there could be, for example, supervision of the appellant in her own home, possibly by a member of the family, possibly by somebody else. But I think that's the gist of what's really being said under ground 3.
Yes.
That just the judge has gone straight to, in effect, adoption, without exploring other possibilities short of that, and at least giving them a chance. What do you say about that?
Well, my lord, the judge has dealt with the issue of support, and in terms of the alternative options, he's considered those options. That there is no family carer available. There is no. The options were either return to mother, removal from mother's care. We would say
that's paragraph 90.
Placement, yes, or adjourn for a psychological assessment. Yeah. And so it wasn't put as an option available to him by any party. That, and I say there is no evidence to suggest there is an option available. Alternatively, that would place the child at home with mother, with the support package in place that remedies all of the concerns that the judge goes through. And fundamentally, in part of that, of course, is the judge's analysis that the mother won't engage in that package. My lord, those are the issues I wish to address, in addition to the skeleton argument. Is there anything I can assist at all?
Can I just check with my lords if there are any other questions for you?
Well, you haven't really said anything much about ground 2, which is the psychological assessment, and what we have now had explained to us and has become a little clearer as a result of the debate earlier, is that in effect there was an informal renewed Part 25 application for the recorder, and as has been explained, that's how he comes to make the statement that he does in, I think it's paragraph 56, about timescales for various experts ranging from 4 weeks and upwards. And it also explains why he says in paragraph 92 that there's no Part 25 application for him, but nobody had taken the procedural point.
No one.
And as was explored earlier, the submission is made that, granted that in effect the application was made informally, no procedural point was made against it, he should have not only entertained the application but should have granted it. Now, obviously I've seen from your skeleton argument that you take issue with that, but can you just help us a bit more as to why you resist the suggestion that he should have acceded to that application?
Yes, my lord. The first point is, of course, Judge determined there was a gap in the evidence.
Well, exactly. That's
the point.
the starting point for the submission against you.
I don't disagree. That's the determination of the court that's made. But I say the judge was right to go on and to consider whether he needed evidence in order to fill that gap to make a determination in respect of the best interests of this child. So it's not just simply identifying a lack of evidence. There are many cases that come before the courts where the evidence is incomplete in some aspects, but whether that's incomplete, that gap, is as a fundamental aspect of the analysis that he has to undertake. And I say the judge got that right, as in identifying it and taking through the steps, applying the correct test of necessity. And I think in paragraph 93, he goes on to say, I think he repeats himself in effect, but it recognises it may have been useful, but it wasn't necessary. And I would suggest that is the right analysis to reach in this case, is that this is a case where there are multiple issues of concern, and the judge has dealt with all of those issues rightly. And one of those issues was his mother's mental health. But on his analysis, it wasn't such an issue that required the necessity of an expert, because the mother was asserting that her mental health was well and stable, that the local authority was not asserting that her mental health was a risk. And therefore, by looking at that, he's undertaking the correct analysis and reached the conclusion it is not a necessary conclusion, which I invite this court to reach, that he's undertaken the analysis correctly and reached the correct conclusion on the evidence that he had available to him. That's equally bearing in mind, of course, he had the benefit of hearing mother's evidence on this point. And so it's not a case where he was dealing with it like Judge Bajir was dealing with it, which in an interim position, all the evidence is not available at that point. And of course, I'm keen to point out, as in Skeleton, this is not an appeal of Judge Bajir's decision, but this judge was right to identify the gap, to undertake the analysis and reach a conclusion that the evidential gap was not such that required him to order assessment, or in fact fail in this particular case. I hope that assists.
So in other words, your submission is it was a case management decision reached applying the correct test and reaching a conclusion that was open to him on the evidence.
Yes.
Yeah.
And I don't take issue with the formality in terms of the procedural point. It's not. The question is the absence of the evidence and the necessity of assessment. The procedural point, I don't think, assists this particular child in this particular case. And the judge was right to undertake that analysis, lest there be a gap had he not undertaken that exercise.
Right, thank you very much. I notice the time. We will resume at 2 o'clock, when you can certainly add anything if, on reflection, there is anything further that you would like
There's nothing further from legal.
But we won't hold you to that, all right?
I
So
understand.
you'll have that opportunity,
Grateful.
and then of course there will be an opportunity